comes before you from the parties is treated equally. And that is why justice is blindfolded. And that is why justice balances in the scales the evidence that comes to justice. This confirmation hearing is not something that we've ever said should be a mini trial. Far from it. This confirmation hearing is an opportunity for us to present before you, for the first time, evidence on behalf of the suspects. Until we started these proceedings, the traffic to you had all been one way. And that is so in any system. An investigation may come about because of direct evidence, because of suspicion, because of rumor. And an investigation thereafter start. A summons issued, again without the people who receive those summons being a party to the arguments concerning the validity of what is put before you, the quality of what is put before you, the accuracy of what is put before you. It is not until our disclosure takes place and the proceedings start that for the first time you as judges get the opportunity to receive evidence from the defense. And that evidence has every right to be considered in the same way as prosecution evidence is considered, fairly, dispassionately, analysed, its quality considered, whether evidence is direct evidence, whether it's evidence based upon information given by somebody else, whether it's hearsay, whether it needs corroboration, how it fits into the pattern and situation revealed by other forms of evidence. And a remark from the prosecution this morning really put this into context for the defense. When my learned friend said, we haven't had time to investigate the defense alibi. An investigation requires you to look at where your suspect was and what he did. I would submit even more so in a case that has a complexion behind it of a political conflict, of finger pointing, of people expressing preferences for their own side above the other. A cautious and reasonable prosecutor in our submission would take such measures. This is, of course, a court with a great responsibility to the international community. Its time is valuable. The issues that come before it are, in terms of criminal legal issues, the largest on the planet. And you judges preside over those issues. Your responsibilities are not only to the direct participants, but also to the victims, as we know, to the international community that has put its faith in the court and pledged support to the court and requires the standards that you represent being executed. And we can see from this confirmation hearing that that has exactly taken place. A very dignified opportunity for both sides to put their best evidence. And that's a phrase I remember from one of the decisions that I think the learned single judge, Madam President, issued. It hasn't been our objective to turn this into a mini trial. Our objective has been to turn it into an analysis of the evidence, an analysis of the quality of the evidence, as well as an analysis of materials that we say should have been put before you if the prosecutor's duty to investigate looking for inculpatory as well as exculpatory evidence had been performed. Because when you take a date such as the 3rd of January and you make that a significant date in terms of the plan that you allege came into operation and the criminal plan was put into effect through direct means, we would have expected any policeman, any person prosecuting on behalf of state authorities, and not least any prosecution counsel, to have wanted that date analysed, examined, carefully, meticulously, to see what those alleged to have been planning did, where they were, and what they did. All the more so, I would have thought, if you have a witness number 4, who has, let's be frank, and I'm not going to go into the detail, given 4 very differing accounts with changes of date, changes of place, etc. I was astonished to hear, for the materials that are before us, that he was interviewed for 9 days. As a defense counsel, even as a prosecution counsel, that would have sent alarm bells ringing in my head as to what was going on in those 9 days. But there it is. We have his statements. We have them there for your consideration. But the detail of what he said has never been investigated by the party opposite. And that surely must be a systemic failure in the process with which we are dealing with today. Other dates, such as the 26th of November at State House, have official records, film, photographs, as well as a large number of witnesses who were present, who took part in events with President Kibaki on that day. It is not enough to come here, given inconsistencies and problems within the content of the statement, and to have failed to have examined the detail by the party seeking to use evidence in support. For such important evidence that goes to the very heart of the validity of this case, at this stage, by the time we come to confirmation, it would have been a reasonable expectation for you, the judges, to have been put into possession of information going beyond that which you had for the issuance of the summons or the request for an investigation. I don't know whether you had witness 4's statement or not. Looking now at your decisions, I think you did, because I can see the content of the material being reflected, and so my guess is that you did. But a judge would have reasonably expected that witness 4, having moved through the evidential chain up into the process where confirmation is sought, and it is a challenged confirmation hearing, that then witness 4 is given a solidity upon which you can rely, particularly given the very public nature of the places and the events with which he had inserted himself. It would not have been too much to have expected a diligent prosecutor to have started to provide you with further evidence to then support the case theory that had been advanced in the separate stages that you have so far considered. That didn't happen. What we had was in fact some other statements. I'm not going to go into the issue of anonymous witnesses, summaries, etc. But we know from the prosecution presentation, which is as good a yardstick as any, that it's really witnesses 11 and 12 that are their so-called important trump cards for the confirmation hearing. Otherwise they wouldn't have been disclosed so late to us. That's the issue as well. But they were disclosed, and we only had 15 days to deal with all 3 of those witnesses. In fact, you would have expected that in the time preceding, that witnesses 11 and 12, who make very important, critical statements to the prosecution case concerning plan, execution of plan, facilitation of the plan, support for the plan, that their stories would have also been accounts that the prosecutor would have sought to have bolstered with external evidence to show the validity of what they say. And let's be frank about it, we're not dealing with saints here in relation to witnesses 11 and 12. As a young lawyer, when I prosecuted at the English bar, one of the rules, if you were calling a criminal as a witness and you were prosecuting was that you sought external evidence to corroborate what this person was going to say, because credibility is important. Prosecution have sought to make credibility an issue in this case with the defence witnesses. So one fails to understand quite why they try to take credibility out of the process that you have to undergo at this stage. And the reason why credibility is important is because you have to have substantial grounds to believe. And you can't have substantial grounds to believe if evidence comes before you that shows a witness is unbelievable. All professional judges, as you are used to making these determinations as part of your judicial office. And that is why credibility is important, particularly if, as with witness 11 and 12, you are calling evidence from, by all accounts, people who are serious criminals, high-level criminals. And criminals and dishonest people often seek to manipulate others. That's what they do. They seek to steal from them. They may seek to cause harm. They're untrustworthy. Their perspective of life is not the same as the men and women in this courtroom and those in the public gallery. They have different motivations, and their lack of honesty and their resort to dishonesty makes it prudent for a prosecutor in any court, in any nation or state, to check the story. Given that that didn't happen with the prosecutor here, what then did happen? We checked the story because it dawned on us that 11 and 12 were people who'd had dealings with us. And quite rightly, we did commission Mr. Summers to investigate this matter, because as lead counsel I was very worried and concerned as to protected witnesses. And people in my team I did not want investigating themselves or each other. I took the step of having Mr. Summers instructed, have access to all data and to provide a report for the court. We didn't know whether we were right.
ukidharau shauri yako sababu kazi yako hainisaidii, yangu ile inanisaidia.
Ninajivunia hii kazi yangu ya maombi nikiombea Kenya nchi nzima.
Najivunia sana hii kazi yangu ya kuzima moto. Wakati unapata na mkasa wa moto, wakati unapiga simu kule au unatoroka, sisi mara hiyo tunaingia pale tunakusaidia kwenye tunaweza.
Mimi najivunia kazi ya tuktuk, maana hiyo ndio kazi ambayo inanipatia mapato yangu, hata kama sio mengi vile, lakini nashukuru Mwenyezi Mungu.
Najivunia kazi yangu. Je, wewe?
Expect more. Stories that will intrigue. Stories that will thrill. Stories that will shock. Stories that will stun. Stories that will touch. Stories that will amaze. Stories just for you. Untold Stories. Every Sunday at 7:30 p.m. Only on K24. All Kenyan. All the time.
Mama Milka bonyo dado sisi nani
Every day I am defiled. They cut my limbs, my feet, my spirit. We have as much right to be here as you. Protect us, care for us, and you will not be sorry.
The assertion that they are credible. In our submission, no one watching these proceedings, no one being involved in these proceedings, other than the advocate of that cause, could reasonably come to such a conclusion. Again, plucking dates from the air, as these people do, because they're not actually involved in these events. They take a date, 30th of December, a date in January, 27th of January, and fix themselves in an event involving the suspects, and that date is meant to then give the credibility in the courtroom about what they say. When they give these stories, they're not really thinking about who's going to come along later and look at it. And of course, that's what we've all done here, and in our own different ways, assembled evidence that shows that what they are saying is simply not true by date or fact or even possibility. The image of the President's swearing-in ceremony, which we've seen here, and the day the money is handed over to these people, 30 million shillings, it is an event and an issue that any policeman, I would have thought, would have had the inclination and the sense to then start looking for evidence of withdrawals of 30 million shillings and what that would represent and how it would get from the banks into the hands of Mr. Kenyatta. 3 or 4 suitcases, I think, was the figure given in terms of how one carries this around. Carrying this into State House on the 30th of December, President Kibaki may have thought he was going to move in and stay at State House rather than coming in for his swearing-in ceremony, because it is a rather ridiculous image. And why it's ridiculous is, and why we can say that, is that it simply doesn't fit the context of the evidence of what was really happening. And that goes the same with witness 4 and the 26th of November at State House. Prosecution raised the 26th of November and the defence alibi on that issue today. If they had done their work, they would have seen he was at the KICC on the 26th of November. And bar going up the steps, going through the building and out the back door to go round to State House, which is an incredulous account, to be frank, and no reason why he should do that, which seems to be the proposition that was being put forward. The fact of the matter is that it was President Kibaki who was holding the meeting with the youth on that day, and it was he who had had his rally the day before with the youth. An important document, the charter, had not been given to him, and so they had their special meeting with the president the next day. Absolutely nothing to do with Uhuru Kenyatta. And if you look at the evidence, you'll see from my opening, I referred you to it, that President Kibaki had been scheduled to go to the KICC meeting, but he skipped it. And that's the headline in the newspaper. He skipped the meeting. And he went to the lunch later on at the Intercontinental. So the evidence clearly demonstrates, and Mr. Kenyatta gave you the time to show, that he and President Kibaki were not at State House that day because Mr. Kenyatta went to the KICC, Mr. Kibaki skipped it, but then Mr. Kibaki went to the lunch. If you're going to try and pick holes in things like that as a prosecutor, I suggest you come with a timeline, you come with evidence, and you come armed to a courtroom, having investigated and researched, and you stand on a firm base with a firmly projected case as to what happened on a particular date. And these are not throwaway proceedings in the lives of these people. This case has great significance. Court knows that. The whole of Kenya knows that. This case carries with it a significance that goes beyond the charges here. And that is why we have asked for a very careful and rigorous examination. Because in our submission, what has been put before you is not well researched and investigated by the prosecutor, and doesn't deserve the status of being confirmed, and you as judges will be aware, as I know, of your responsibilities in relation to that. these proceedings have been an opportunity for us as well to present direct evidence. Mr. Kenyatta took the first opportunity to give evidence before you. He gave his account, and then he was available for cross-examination. This moved this case beyond, they're not testimonies that you've been given by the prosecutor, they are statements. They are not testimonies, they are statements. They are reports, they are documents, they contain many accounts. This moved this case into the realm of directly being able to establish the case that you have. In the cross-examination of Mr. Kenyatta, what smoking guns were put before this court concerning his alleged acts and conduct? What was put to him concerning the 3rd of January and the Nairobi Members Club? What evidence was there that the prosecutor was able to put? And I'll tell you why the big issues in this case were not grappled with and grasped with in that 1 hour. And the big issues are fundraising, money, meetings with Mungiki, commanding the Mungiki, etc. And it often happens in a trial, and it often happens in these sorts of proceedings where you look to see if there's going to be a trial. What happened was, we had reached the stage in the proceedings where the prosecution case was visibly an utter failure. That hour that we watched, that hour that he was available for questioning, was a demonstrable hour to show what you had, why you had it, and what you could do with it. We were prepared to face that hour. You will have seen I've never objected concerning time or issues such as that in this case. If prosecution had wanted to go on, they could have. In fact, they went short. They couldn't even fill that hour. It was an empty hour. It was an hour that had every opportunity to put this case and to establish if there was substantial grounds to believe. But that hour failed. Likewise, when we turned to Mr. Louis Ngai, and he gave his evidence. He wasn't challenged about witness 11 and 12 not hanging around the jacaranda. He wasn't challenged that they were looking for money and didn't even have the money for a bus fare or to top up a phone. He wasn't challenged when he said they wanted to be involved with Navasha and said it hadn't been a clean job, they would have done a better job. This is direct evidence about key witnesses as to what they said and did. And again, the reason why that challenge didn't take place and that evidence put before Mr. Ngai to show he was wrong about whom he'd identified, who'd been at the Jacaranda, and what they had said and did, was because the evidence failed the test that it was being given. And that was the purpose of calling that witness, to give the prosecution the opportunity or not to establish the substantial grounds for their case and their allegations. It failed. It obviously failed. It was visible to all. It was even rather, I won't say humorous, but it was even rather light-hearted at the end when I asked, did they look like men who had 30 million shillings? No, even 10%, and then he said they didn't even look as though they had 3,000 or whatever. And those moments in any criminal proceedings are telling moments as to whether there is a case or not. I understand why the court have limited the number of viva voce witnesses. We get that point, and you take your opportunity to call your best evidence. In this case, obviously, the client, Uhuru Kenyatta, because he can answer questions anyone wants to put to him, and then Louis Ngai, who, unbeknownst to him at the time, was able to provide the link to witnesses 11 and 12 and what they were actually saying and doing. It's all very well standing up today and really putting your case as you did on the first day, except without the legal context, and making a very spirited fight for it. But anyone listening would have thought the evidence is being ignored here, and what has taken place in the last couple of weeks was as if it never happened. It did happen. And it happens now that for the first time you are in possession of it, and you get that opportunity to consider it and put it into the scales. In our submission, eyewitness evidence and people who take part in events, who give statements, is important evidence to take into account. And we've attempted to do that for you. I'm not going to recite that now. I'm just going to look at a couple of matters, and I think I only have a few minutes looking at the clock, just to make points, and I'll confine it to one. It is the use of the Professor Kagwanja articles, 2003, 2005. What's important to remember was that he was from the other political side to Mr. Kenyatta's. He was Mr. Kenyatta Kanu. This man was in the NARC party. And you will see evidence within the statements we filed with you particularly from one witness who was a part of it, because he was in NARC at that time as a young man, of how there was a plan and policy to link Mr. Kenyatta with the Mungiki so that his electoral chances were spoiled. If ever there's a vote loser, it must be the Mungiki, I would have thought. And that's what was happening. And this man, Professor, I don't know what he's a professor of, it may be of propaganda, but he is the Dick Morris equivalent that we saw in our ODM press conference film on the first day. A strategist, as you heard, is someone who tries to influence outcomes in relation to politics. And his article, when put to Mr. Kenyatta as the link that was being put to him concerning the Mungiki, was in fact not represented, and I'll say this carefully, by the questioner. He referred to page 63 of the Kagwanja article, EVD PT OTP 00158. Uhuru Kenyatta himself swung between publicly distancing his campaign from Mungiki's acts of terror and covertly soliciting Mungiki's support, arguing that anybody had the freedom to support whoever he wanted. And the professor cites the Daily Nation of the 23rd of August 2002, which we've actually submitted to you because it shows the opposite. EVD PT D13 00335. Cabinet Minister Uhuru Kenyatta has denounced the Mungiki sect, saying that the members did not win his favour by holding a demonstration in the city streets on Tuesday. In an angry response to questions about his relationship with the outlawed group, Mr. Kenyatta said his hopes to ascend to the country's presidency lay with the registered voters and not the snuff-taking members of the outlawed group. He denied having any links with the Mungiki, saying he had no control over any group that decided to demonstrate in his support. How many people run up and down the Nairobi streets shouting support for A, B or C, he asked. And as proof that there was no love lost between him and the group, Mr. Kenyatta cited an incident 2 years ago when the group burnt his effigy just outside my father's mausoleum, is how the piece ends. Well, there we have it. A proposition that was put, not founded on accuracy, either from the source and indeed what was actually put to Mr. Kenyatta when you go and look at the transcript. So there we are. That's the kind of material we are facing here. Is it good enough? In our submission to this court, it's not good enough. And any reasonable party observing these proceedings will have been conscious of that. And this case, now in your hands, for the first time with defence evidence, is able to be stopped, charges not confirmed, in view of the evidence that you have received from all the parties. I thank the court.
Thank you very much, Lead Counsel Kay.